10 minutes.
Other judges will say, all right, come back, Some judges will see big volumes of law books and not ready to work. So we need to find new strategies to unbundle the work of judges. And hopefully this Speed of Justice project will appeal to the CJN, to the CJs, and we can get it going.
You talked about the NJC, the CJN, all those other stakeholders, but what essentially do you want all these parties to do? How can they get involved in this Speed of Justice project?
What I want them to do is to understand that the operating model of the courts, that's the rules and the other protocols, are too old. Okay. Number one. Number two, the judicial and legal culture of managing cases, both in terms of presentation by lawyers and adjudication by judges, is outdated. In England, is the medical surgery approach. No judge has the chambers. Judges have their own chambers separate from their courtrooms. So you can have the Apapa division of the Federal High Court, 40 hearing rooms. You don't know who will come to the surgery. It could be anybody. He comes, everything is front-loaded. So he hears you and he treats your case, and it's like a continuous turnover. But when judges sit in their chambers, have their courts are next to the chambers, it even doesn't allow enough judges to be appointed, if that's a problem. So with this, in England, for instance, the Supreme Court sits in a room just as big as mine. They don't sit robed, they sit dressed like this. Mm-hmm. So this ceremonial high bench also causes delay. There are lots of things that can be done by the exchange of documents between counsel and the judge is intervening. In other words, if we introduce the arbitration model into adjudication, we will pick up a lot of speed. To amend, for instance, can you believe that to amend sometimes a court document can take a year? But if the court has power of its own volition, what we say suo motu, and another problem is language. All this suo motu and that must go. You must simplify. My lord, I want leave to. Leave to what? Just say permission to. Okay. Simplify the language. Make it easy for everybody to understand. Converse in simple terms. And judgments must not be overloaded. In the NJC, Justice Ayola is the chair of the Performance Evaluation Committee. One of the greatest obstacles to delay is that judges don't have enough time to write judgments. You know why? It's because in their minds, there's a mindset about how to write it. Somewhere along the line in the 70s, the judicial system got it wrong. It felt that judgments would have to be tomes, 20 pages, 30 pages, 40 pages.
That's because of language too?
Because of language and style. Okay. So that you find the judge will copy out the claim and defense, copy out the evidence, copy out the...
How many witnesses were called?
Everything that happened in the case, then summarize and give judgment in 2 pages.
Yes.
In the old days, that was necessary. The judge would just evaluate the case and give his judgment in 3 pages. So he was able to do with a lot more cases than judges do. Because
what happened? How did we go back?
I don't know. I don't understand how we went back. I don't understand how we slipped. So that's part of what the Speed of Justice project is designed to achieve. Is it always necessary to? Can't you give a bench ruling? These cases are very simple. You hear a case, the witness has spoken, given evidence in court. The other side has given evidence in court. But if you tell the average judge, you say no, I must go and reflect.
Because I even find that simple things such as even giving bail, judges would go back and say come after 3 days when it's something they could decide on the spot of the moment. And some judges do that. Yeah. But some others will say, okay, adjourn for 3 days, let me go and consider whether I will give bail in an offense that is ordinarily bailable.
Absolutely.
So
that's part of the...
Why do we go back and forth?
Well, that's part of the problem.
And there's no uniformity. One judge will do this, another will do another thing.
That's part of what I hope will happen in the Speed of Justice project, that, with training, with seminars, with continuous education, that judges will come to see that the principles upon which bail is granted proceed on 3 tracks. So there are some types of bail applications in which the judge mustn't grant bail. Another where he has to grant bail. Another where he has a discretion. So if I was a judge, I would ask, prosecutor, this is a simple offense. I'm going to grant bail. Tell me why I shouldn't grant bail. That's all. The principles upon which bail is granted is settled in many cases by the Supreme Court, so it's clear to everybody. So my point is, can we identify all the clogs in the wheel of justice and see how many we can remove? This cash payment thing is one. The way cases are filed, 2. The way cases are assigned, 3. The way cases are managed by the judges, 4. That one is very crucial, because the judge is, as I said, master of his court. We need modern judicial, attitudes. So that's what I think will be good. Because at the end of the day, those who suffer are those who use the courts.
Yes.
I mean, a guy will be in jail. I remember when a guy came to see me and was saying that so-and-so had been 4 years awaiting trial for writing the bounce check because the chain hasn't let her visit the courts. That's terrible. It has to happen to somebody to understand how bad the system is. So if 2014 is going to be, of course, election year, so the court administration needs to be at its best. Right now it's average, and I'm sure that if we all contribute to resolving the problem, we can come up with a transformational agenda that will change the issues.
So the way to contributing to resolving the judgment is perhaps a meeting of all stakeholders, or what? What are the specifics of how everybody gets to contribute?
Well, you see, the fact is that I'm just a lawyer, so it will require the cooperation of the highest organs of the judiciary. And that will be the CJN, the NJC, the NJI, the NBA. And incidentally, I've been in all of these processes. So I think what is important is to prioritize it, is to advocate upon it, and I'm prepared to do that. So once we have that cooperation and the energy is released, I think the problem will be solved.
On the home stretch, we turn our attention to the intrigues playing out in the Nigerian Bar Association ahead of the July elections for a new president from the Southwest.
We've been holding meetings.
15 branch chairmen of the Nigerian Bar Association in the Southwest have endorsed and adopted Mr. Dele Adesina as the region's flag bearer for the 2014 NBA presidential elections to be held in July.
I'm present here, physically
at a meeting held in Lagos on Saturday, the 18th of January, the interim chairman of the Egbe Amofin, Mr. Adebayo Ayodele, who is also the chairman of the Abeokuta branch, read out the names of the branches in support of the candidacy of Mr. Adesina. 10 of the branch chairmen were physically present at the meeting, while 5 others sent the vice chairmen and or secretaries to represent them. Those who were physically present include the chairman of Abeokuta, Ikere-Ekiti, Ondo, Ogbomosho, Shagamu, Badagry, Ikorodu, Ado-Ekiti, Ikeja, and Owo. Those who sent apologies and other representatives were the branch chairmen of Ikirun, Ota, Ikole, Okitipupa, and Ife. The interim chairman of the Egbe Amofin read out the communique from the meeting.
15 branches here, out of the 23 branches in the Southwest geopolitical zone. The House reviewed the affairs of the Egbe Amofin, particularly the affairs of the splinter group led by Shibamide Laiku, who is presiding over a meeting at Ibadan right away. And we hang our position on the fact that democracy must be driven by the majority. And that is what had been done, and we stand firmly by that. And Sorry Drive must be premised on the pedestal of fairness, equity, and justice. Maybe the Ibadan meeting was aimed at destabilizing the Egbe, but we remain firm and resolute that nothing could move us or change us from our stated position. The members using Chief Aiku did not, maybe did not know some members were using him to destabilize, but we shall resist that. We shall continue to extend our hands of fellowship to all and sundry, because Egbe remains one, an indivisible one for that matter. The House reaffirmed the support and mandate given to the King Julius Oladele Adesina at the December 7 meeting, 2013 at Akure, as his adopted candidate, democratically nominated, elected, premise on due diligence, nomination from all branches. We hereby reaffirm it and repose absolute confidence in him as our worthy flag bearer.
23 branches make up the Egbe Amofin, which in 2008 endorsed Mr. Rotimi Akeredolu as the candidate of the region. He went on to become the president of the NBA. The presidency then went to the north and the east before returning to the south, where 4 candidates are ready to slug it out at the elections scheduled for July. The candidates are Mr. Austin Alege of the Midwestern Bar, Mr. Nii Akitola, Mrs. Funke Adekoya, and Mr. Dele Adesina, all senior advocates of Nigeria.
The days ahead will no doubt produce more interesting twists as the elections draw closer, and we'll stay on the developments and bring it to you as they unfold. That is the program this week. Do remember that you can watch it all again by logging into www.youtube.com/channelsweb. Send us your questions and comments via email or Facebook, and click the follow button on Twitter to interact with me. I am Shola Sheyeli. Thank you for watching.